Okay, so let's get started and introduce Gary. So I want to welcome everyone to tonight's program on estate planning, and it's my pleasure to introduce our guest speaker, Gary Altman. Gary is the founder and principal attorney of the estate planning law firm Altman and Associates, where he has been serving the Washington metropolitan area, practicing law since 1980 and estate planning since 1988. A nationally recognized estate, legacy, and business planning authority, Gary's outstanding expertise, trustworthiness, and commitment to his clients' needs have earned him recognition by Washingtonian Magazine as among the DC region's best estate planners. He has also been repeatedly honored as a top 100 attorney by Worth Magazine and likewise recognized as a Maryland and Washington, DC super lawyer. As a trusted legal analyst, Gary has lent his expertise and authored articles for a wide range of media outlets, including the Washington Post, the New York Times, the Journal of Financial Advisors, and more. As an industry leader, Gary has taught various estate planning courses to attorneys, accountants, and financial planners. He is currently on the board of Hope Connections. Thank you, Gary, and serves on the investment company of 2 local charities. Gary has previously served as the president of the National Capital Area chapter of the Financial Planning Association and the National Capital chapter of the Society for Financial Service Professionals. Gary, we are thrilled to have you here with us tonight, and I'm going to turn it over to you.
Okay, and have you made me a host or something?
I did. I made you a co-host, so hopefully you'll be able to share your slides with us.
I am. It's just going to take me about 2 seconds.
Okay, take your time.
How do I get the slideshow? I'll get rid of that. Okay. Hello, I hope everyone can hear me. I realize it's hard to see me. My camera is not focusing when I zoom it in. So that may be better anyway, but I'm going to do it this way. As Stephanie said, I've been doing estate planning for a really long time. My office is right up the street from Hope Connections' new facility, which is on Grosvenor Road. I hope one day you all get to see the gorgeous mansion and all the new rooms and things that can be done there. So I'm just going to really talk about basic estate planning, some stories, hopefully I'll tell, and then I'll open it up for questions. Now that's again me. We don't need to see me. Okay, so the question I get asked a lot is, does someone need an estate plan, or what is estate planning? So you need to do estate planning documents, which will include wills, maybe trusts, powers of attorneys for both medical and financial decision-making, and maybe some other documents. If you want to decide who's going to be making decisions for you, where your assets are going to go, and who's going to manage the money you leave behind. Because if you don't make these decisions, a court or the state law will make those decisions. If you have a child who happens to be disabled and you don't have a good estate plan, that child's inheritance may disqualify him or her from public benefits. Okay. So, and do you want your heirs to waste money fighting over your care while you're alive or your estate after you've gone? I once did a contested guardianship. That was the worst experience of my life, and we will no longer do contested guardianships, because a guardianship is when someone didn't do these documents. A child or someone else says, oh, I need to make decisions for the disabled person. They go to court, they request to become that person's guardian. Some places it's called conservator, but guardian here in Maryland. And then they give notice to the people who would be interested. So if you have 3 children and one goes to court and says, I want to be guardian, another child may say, no, I want to be guardian. And then there's a fight. And those court fights can take years and cost a tremendous amount of money. You and your family are much better off if you can decide who you want to make decisions rather than letting your ass fight over it. And you need an estate plan if you think one of your heirs, your children, your grandchildren, your nieces, whoever it is, will spend their and deplete their inheritance or become susceptible to fraud and abuse. And finally, some people want to avoid what's called the probate process. I'll talk a little more about that. Death or income taxes. I'll talk a little bit more about that and how we could avoid that. Okay, so a good estate plan is one that's going to make decisions during your life and death. I mean, in other words, who's going to make those decisions while you're alive or death? Be actually tailored to your specific family and assets. No estate plan we draft is the same. Everyone's different because everyone has different families, different family dynamics, different assets. And so the words that I write, and that's what all that estate planning is me writing words, will be different for every single person. Most of estate planning is really geared to ensuring that assets are going to be distributed to the right person in the right way. Okay, should it be outright so they have total control over it so that their creditors can reach it, or should it be in some sort of trust? We believe a good estate plan should make sure things happen quickly and effectively. In other words, so I make less money when people die. And minimizing any taxes, and there could be income taxes, gift taxes, estate taxes, generation skipping taxes. And finally, a good estate plan should protect or control someone's inheritance if that's going to be appropriate. And we're going to talk much more about that. Okay, so common documents that I draft, which most people have: wills, revocable trusts, an advance medical directive, a financial power of attorney, a medical release form, a designation of who's going to make funeral or cremation decisions, sometimes irrevocable trusts, and sometimes other tools and techniques. The other tools and techniques really will only come into play if you have if your assets are more than the amount that would pass free of estate tax, which right now is a little shy of $13 million for the federal government and $5 million for the state of Maryland, or if your family is pretty dysfunctional. All right, what is a will? A will is a written document. In Maryland, it has to be a written document and signed, wet signature. That means you sign it in the presence of 2 people and a notary. That may not be true in the future and may not be true in every other state, but it is the law in Maryland, DC, and Virginia. It names someone to be in charge, which everyone thinks is called the executor, but no state uses that. Almost no state uses that word anymore. They usually use a word like personal representative. If you had a minor child, or if you had a special needs child, you could name a guardian for that person, and names beneficiaries, who gets what, when, and how. And then the world has changed. So our wills now have provisions for digital assets, what's called college savings plans or 529 plans, personal effects. And in the Washington, D.C. area, we have a lot of clients who have international issues, which could include having to appoint a guardian for who lives in a foreign country. If you have assets in an EU country or may end up in an EU country, we may want to elect to have U.S. law control and some other factors about it. I think about 10% of our clients have a international estate planning concern or issue. Okay, if you don't have a will, then each state has a will for you. It's in the law. Okay, it's called intestate succession. And again, every law is different. So if you owned real estate in North Carolina and you lived in Maryland and you didn't have a will, your real estate in North Carolina is going to be governed by the North Carolina law on intestate succession, and the rest of your assets under Maryland law. The court will appoint someone who they think is the right person to administer your estate. And if your kids are fighting, it will be a lawyer. And if you had minor children or a disabled child, they will appoint someone to serve as a guardian of that. Okay, again, dying without a will, if you had a minor child or you had someone with special needs, you need to appoint a guardian. And you don't want assets paid directly to someone who has special needs, like IRAs or life insurance. That could become a really bad result, especially if that person's on some sort of benefits. Trusts are used to transfer wealth to heirs in a controlled manner. Revocable living trusts are used to avoid the probate process. Trusts for the benefits of minors allows for the wealth transfer to minors in the best way possible and gives detailed instructions. Irrevocable trusts for adult beneficiaries could be either to control the inheritance. Let's say you had someone, a beneficiary or child who had a spending problem, or a daughter or a son-in-law who had a spending problem, and you wanted to make sure that your assets weren't going to be spent, but instead paid out over their lifetime. I just had a client of mine who's been my client for 30 years tell me they're worried about their son's wife, and instead of giving the son the inheritance directly, they decided that what they want to do is give their son an income stream each year. And so the son will get money every year to get paid to him, but this way we'll make sure that the inheritance, when the son dies, goes to their grandchildren and not to their daughter-in-law's children, which to them is very important. Sometimes we do irrevocable trusts to protect beneficiaries, protect them from creditors or divorces or other bad things. And then irrevocable trusts are used to avoid for tax savings techniques. So again, irrevocable trust, and if people do irrevocable trust, the goal is for the trust to own their assets. And the purpose is to avoid probate. Okay, really, that's the main purpose of a revocable trust. There are alternatives to revocable trusts. Joint tenants would write a survivorship, transfer on death, paid on death, and trust for and beneficiary designations. These are alternatives, and these are inexpensive ways to do estate planning, which may backfire. So let's talk about joint property for a second. So people always say, well, why can't I just put my financial account in joint with my kids? And you can. And that's simple and it's easy, very little cost. It does avoid probate. And if it's a bank account, we'll allow your daughter, who's joint tenants on your checking account, to write your checks. But what bad can happen? Well, if it's a joint account and your creditor and your son or daughter gets in a car accident, their creditor can take your assets. If your son or daughter gets divorced, it is possible the child's ex-spouse could take your assets. And it is possible that your child, who you trust implicitly, will borrow your money because they have a financial problem. Upon death, if a child owns the assets directly, it's subject to their creditors' lawsuits, bad marriages, bankruptcies. And what we see a lot is that it leads to family fighting and failed estate plans, because it doesn't always work, and not everyone is named on it. It causes accidental inheritance, and then sometimes there's insufficient resources to pay debts, funeral expenses, taxes, and things like that. TOD, POD, ITF are similar. Those are accounts where you name someone to get your assets when you die. It's the only time it takes effect. But if you have 3 children and you named your financial account transfer and death to child A, child B, and child C, but child C dies before you, which is horrible, child C's kids will be disinherited, because paid on death only goes to live people normally. Some beneficiary designations only go to the people you name and not to their children. Okay? So again, the same sort of negatives, the same sort of positives. It's pretty simple, but it can lead to lots of bad estate planning. And if the purpose is to avoid probate, which is the only purpose to doing these types of designations, do a living trust. It avoids probate, has no conceivable problems whatsoever, and has most of the same positives. Everyone, no matter how old, needs an advanced medical directive. An advanced medical directive has a couple components. One is like a living will, which will say, do I want treatment continued if I am not likely to survive? Okay. We need to, some very specific provisions are needed in here about artificial food and water, whether it should be withdrawn or not, whether you should be forced to swallow food, and whether the DNR, feeding tubes, life support. Also, it will have a medical power of attorney in it. You need to name someone to make medical decisions for you. Okay, which could include the same rights to request or refuse treatment that you would have if you were capable of making your own decisions. So when you grant someone your medical power of attorney, you're granting them the right to go talk to the doctor and make medical decisions. What the document does not do is authorize the doctor to talk back. And for that, you need what's called a HIPAA release. Everyone on this call has signed multiple HIPAA releases in their lives. Every year when you go to your doctor, most doctors will have you sign a new HIPAA release, which authorizes your doctor to talk to the nurses and staff at the facility. If they don't have that waiver, they can't even talk to their own nurse. And they're not going to talk to your child unless they have a waiver. Okay. When I see these documents, there's always 2 lines which say other people. Okay. I may be the only person in the world who fills out those other 2 lines. And I always put on those 2 lines my spouse and my 2 children, because I want them to be able to talk to my doctors if I can't. I've also signed, and everyone should sign, a standalone document that allows the same things. A durable financial power of attorney is where you appoint someone to make financial decisions for you, like writing checks, like filing tax returns, like making gifts, like entering your safety deposit box, like selling your car, anything. A power of attorney can be effective when you sign it. That's effective immediately, only effective upon the occurrence of an event like disability. So most of our clients sign them effective immediately. Sometimes we do have them effective only upon disability. And the question would be, why would I choose that? And the answer is, If you don't trust the person who's going to be making financial decisions for you, then absolutely make it only upon the occurrence of disability. But frankly, if you don't trust the person who's making financial decisions for you, you shouldn't name them in the document. And if it's effective only upon disability, then the person cannot just go and be able to write checks. They have to get a doctor or two doctors to make a determination that you are incapacitated. Some financial institutions make doctors recertify every so often. And the problem is that there is a long time between full competency and total incompetency. And during that time, your doctors may not say you're incapable of acting, but you may be mostly incapable of acting. And it may make sense for you to allow someone to make financial decisions for you. So this is a very tricky subject. And there are stories and movies about people taking advantage of folks when they are their guardian or financial power of attorney or medical power of attorney. And I can tell you, in my 30 plus years of doing this, I believe we have only experienced 2 times when someone took advantage of my client. Okay. So that means 6,000, 7,000 clients, 2 times out of 7,000, which is 2 times too many, but isn't a very large percentage. Okay. And in both of those cases, if I had to think back on it now, I would say that my client wasn't fully cognizant of what they were signing at the time they signed it. They were competent, but maybe they were being influenced. And so we, over the years, have become more and more cautious about this. And we will never prepare a document without talking to someone, and we will never have a client sign something unless we're 100% sure that they're competent and they know who's going to make decisions. And sometimes that's, again, a tricky determination. So the agent's job is very important, and they have to keep records because they may have to account for everything they've done. Okay? So they'll be given broad authority, but they have to keep records. And the one thing an agent can't do is use your money for themselves. It's not allowed. It's against the fiduciary laws, and they can be held to account. So when you decide who you're going to be your agent to make financial decisions, make sure that person understands that they're acting as a fiduciary and they have to account for it. They cannot just say, I'm going to write your checks and never balance your checkbook. They have to account for it. We recommend everybody use a spreadsheet or Quicken or some other program to account for the money, because one day it may be needed. So in a good estate plan, we're going to advise our clients on making sure that their beneficiary designations and the title of their assets are coordinated with their estate plan. Okay. We believe this is a team effort. It's not just Gary Altman writing documents. It's Gary Altman writing documents, the client talking to their advisors, or I talk to their financial advisors, and make sure that everything is coordinated in this. Okay. Beneficiary designations must be reviewed upon marriage or divorce and a birth of a child. I can't tell you how many times we've had someone die and an ex-spouse or a deceased parent was the beneficiary. When my sister died in 2005, my father, who died in 1997, was named as the beneficiary of her life insurance. Actually, it was an annuity, I think, or it was one of those two. And I tried to change it by her power of attorney to make it be me and my brother, her only heirs. The life insurance company wouldn't let me do so because they said it was a conflict of interest, even though my power of attorney said I could do so. So you need to look at this, okay? It causes, what it causes is time and money. Time because it takes longer to get the asset, and money because usually you need a lawyer to help you, okay? Bad estate planning is going to have a minor or disabled child as a beneficiary or something. Or I just had this new client. She has two children, one of who is disabled, one of who is addicted to drugs. And she named her nephew as the beneficiary of her assets because she wanted her nephew to disperse them the way she wanted. And the nephew didn't want this. And he referred her to me. And I said, the problem with naming your nephew is that your nephew could die. And all of a sudden, his assets become his wife and kids, and they won't be used for your kids. Your nephew could have a financial problem or a divorce, and they will take your money. Or your nephew may just turn into be a bad guy. So she agreed, and so we are drafting the right documents so that her kids will be the beneficiaries of a trust that the nephew will control. A much better estate plan, and one that will work. So you need to do special planning, special trust planning for people who have special needs, who are minors, who are immature. I realize I don't know how many people are on this call. I can't tell right now. But I would guess out of the 20 or 25 people who are on this call, one or more of you has a beneficiary who you know if you gave them $100,000, it would be gone tomorrow. Okay? And that you need to make sure that the money is not wasted. Maybe one of you has a child who has a drug or alcohol spending or credit problem. And every one of you probably has a beneficiary or child who should be protected from creditors, predators, and bad marriages. Okay? And we'll talk about that in a second. Special needs trusts, there are different types of special needs trusts, but basically the concept is hold the money in a trust so the disabled person can enjoy the money, but it won't disqualify them from needs-based government benefits. There are things called first-party special needs trusts and third-party special needs trusts. If you were creating a special needs trust for your heir, beneficiary, or child, it would be a third-party special needs trust, and it can be much more flexible than what's called a first-party special needs trust. But there are some limitations, and so we now make sure that our clients who have children or heirs with special needs also fund an ABLE account. Because an ABLE account can be spent for things that a special needs trust cannot be spent for. Basically, food and housing. It's strange to say this, but if you create a special needs trust for your child, that special needs trust can't pay for your child's food. Because that food would be considered a resource and disqualify him from benefits. Can't really pay for their housing either. You could own a house for them, but can't pay for housing. So you can't pay for rent, but you can pay for a house. Don't ask me why the rules are what they are, but they are. But an ABLE account can do those things. So we coordinate our special needs trust with ABLE accounts. Spendthrifts or discretionary trusts are for beneficiaries that can't control their own spending. Okay. You know, as I like to say, I would not be in practice. I would not be able to have the practice I have if there were no dysfunctional children out there. Okay. I can't tell you how many. Don't feel embarrassed if one of your children has a problem. There are lots of adult children who have problems. And don't say, I'm just going to give them the money, I don't care. Because if they blow it, they blow it. And that's an okay sentiment, but you may want to make sure that the money's there for the rest of their lives. Okay? It may be better to give them $30,000 or $50,000 a year for the rest of their life than to give them $300,000 or $500,000 and they blow it in a year. Okay? I can't tell you what to do with your money, but what I can tell you is that if one of your beneficiaries has a spending problem or has creditors or has a drug problem, I'm not so sure you worked hard for your money all these years to have it wasted in 1 year. Protective trusts are trusts that we create for your mature, responsible children and heirs. Okay, those who you know they're not going to blow it. But maybe we're going to put it in a trust for them anyway to protect them. And we're protecting them from things that may be outside of their control, like creditors, like lawsuits. Everyone drives a car and everybody can make a mistake, especially with the new bicycle lanes in Montgomery County. Okay, now that's a little bit of a joke, so I want to tell you that, okay? But I drive on Old Georgetown Road every day and I make a right turn and I am convinced once it gets warm, there's going to be bicyclists who are going to be on that road and not paying attention to a red light or green light. And it is very hard to see, we'll be able to see that person when you're making the right turn because you're making it so far away from the curb. Just my 2 cents there. And there's already been 1 or 2 accidents on Old Georgetown Road since they put it in, and I suspect there's going to be more. So the point is that it's not always someone's fault. It's not someone's fault that they get divorced. It's not someone's fault that they get old and end up in a nursing home. But if you put your money in a trust, which could give your beneficiary, your child, a lot of discretion and control to spend the money, to direct where it goes, to do everything, then the money's protected. And why not? Okay? Now, I'm giving a talk tomorrow on income tax and irrevocable trusts to a bunch of CPAs who will say to me in that talk, irrevocable trusts will cost people more money in income taxes. And the answer to that is first is maybe, and secondarily, it all depends on what the trust purpose is. So again, should you do this for your children and heirs? I think so. I've been doing this for my clients for 30 plus years, and the heirs who receive it are happy. My clients are happy. And it has protected the inheritance in at least 2 cases from being taken due to a car accident. And it's protected the inheritance in many cases from divorces. So it's a good thing to do. There are lots of other types of irrevocable trusts. Whether or not these are important depends on your situation. An incentive trust is one where you say, if my child makes $30, I give them $30. Not my favorite type of trust. There are pet trusts, which I forgot to list here. You may have a pet that you like and you want to provide for after you die. I don't know if you watch Netflix, but there's something on there called Gunther's Millions. I think that's what it's called. It's about a trust for a dog named Gunther who inherited $500 million. And what the trust does, it's very funny and very disturbing to watch this. So I don't think you should have a trust for $500 million for your pet, but you may want to have a trust for your dogs. If you had 3 dogs, you may want to have a trust to pay for them while they're alive. You don't need $500 million, but maybe you need $500,000 to do that, okay? A total return trust is like when we give someone the income, okay? Could be really important. The next most likely trust is if you lived in DC or New York or Massachusetts or Connecticut or some other states, they have an estate tax on their own, and we may want to use a trust to avoid some estate tax. More complicated trusts are what called IJITs or quists or ISBITs. Quists and ISBITs, if you have S-Corp stock. You may want to do a marital trust, which sometimes is called a Q-tip trust. Another marital trust is called the Q-dot trust, and that is if your spouse is a non-U.S. citizen. We do trusts for very complicated planning for around something called the prior tax credit. We sometimes do trusts so you can make gifts to it each year. The current gift tax exemption is $17,000 per person. Sometimes we do trusts to own life insurance. There are even more complicated trusts, okay? I'm not going to even talk about any of these. If you have a complicated tax situation, these trusts may be necessary, but you got to have a lot of money. Okay, the amount that passes free of federal estate tax for a single person is $12,920,000. That's a lot of money. It's doubled if you're married to almost $26 million. Now, that number is going to be cut in half on January 1st, 2026, unless Congress acts. Since Congress is so dysfunctional itself, I can't imagine they're going to act. But then again, Congress has acted to preserve these things in the past. So who knows? Okay, since I'm doing this for Hope Connections, I'm going to talk a little bit about charitable planning. Okay? So I have many clients who want to make charitable gifts while they're alive or when they die. So the best way to give money to charity at your death is as a beneficiary of your IRA. The absolute best way, okay? The problem is that unless you're going to give the charity a percentage of the IRA, you can't give them a dollar amount. Also, if you're going to do it, it should be somewhat significant. I think Hope Connections was the beneficiary of a retirement account or life insurance, and all they received from it was $1,000. And the effort in collecting it was more, it took more effort than it probably was worth it. So if you're going to give money to charity, give them a good amount, first as a beneficiary of an IRA, then as a provision in your will or revocable trust. We have a very special provision in our trust to allow for an IRA to be paid to the revocable trust and then to charity and not pay income tax on the money going to the charity. So how we do it for each client depends upon the amount of money we're talking about and what we're trying to accomplish. There's something called the qualified charitable distribution. So when I saw pictures of the people on this, I noticed that at least one of you is over 70 and a half. And if you're over 70 and a half, then you have the right or an ability to use your IRA to make charitable contributions. And the answer would be, why would you do this? And the answer could be, well, you want to give $10,000 to charity, and you have no other deductions you can take against your standard deduction of $12,000 for a person or $24,000 for a married couple. And so therefore, if you gave the $10,000 from your assets, you get no deduction, but you still had to pay tax on your required minimum distribution of $10,000. So if you gave it from your IRA, you don't pay the tax on it. So there are some good reasons to do this. It will depend on your situation, but it should be thought of, okay? And I know that Hope Connections does get a couple of qualified charitable distributions each year at the end of the year, because it does make sense for people. The other way, while you're alive, is give to charity an appreciated stock. Let's say you bought a stock at $1 and it's now worth $100. If you sold it, you would pay capital gains tax. If you gave it to charity, you get a deduction of $100. So sure, you don't. So you're avoiding paying capital gains tax. You're making a charitable contribution, and you're able to deduct $100 from your other income, which saves you maybe $35. So what you gave up was $70, which is the amount if you had sold it, and you end up with $35, but you made a charitable contribution. It really only cost you $35 out of $100. So giving appreciated assets makes a lot of sense. I realize that's a very complex example, which probably no one understood or followed. So what I want to say is it's a good way, if you had a choice, to give a check for $1,000 or a stock worth $1,000 that you paid $1 for, give the stock away. Don't give the check away. There are very complex planning techniques for charities. Suppose you were going to sell a building and you were going to make, and you had no basis, and you were going to make some money. And you said, well, I don't want to pay the capital gains tax, but I want the income, and I want, when I die, to give money to charity. Well, then we would use what's called a charitable remainder trust. You may want to create a donor advised fund or a private foundation that allows you to make a gift today, but decide on who gets the money tomorrow or next year. Some charities offer charitable gift annuities. The older you are, the better they are, but the more likely it is you're not going to get your money back. And then there's something called a pooled income fund. Okay. I noticed one or two people checking their email while I was talking. That's okay with me. I'm not upset much. Okay. But in your wills and powers of attorney, you need to have provisions around electronic assets and records. Email accounts are not transferable. Someone has to have your email account, password, and login. Okay? Monthly recurring accounts, remember, someone must have this information. Maybe it's all on your phone or on your computer. So someone needs the password to your phone or computer. Okay? Someone has to do it. And since all of us change these all the time, you need to have a way to keep a record of the changes as it happens. Okay, I'm lucky. I have an office staff who does this. And I have lots of passwords, lots of login informations for various accounts, for various clients, for other things. And we have a very hard time of keeping up with it. So every once in a while, we check forgot password. Well, if you die and your kid checks forgot password and they can't get into your email account, it doesn't do them any good. This is very, very important. It's important to have the right provisions, but it's equally important to tell someone and write it down. So the only other thing I want to say is estate planning is a process. It's not a product. It's not a one-time event. I have clients who I have had for 30 plus years who I see every once in a while. Okay. And I know everything about them. Okay. I had a client come in last Friday. I think the first time I worked with them was around 1997. So what is that? 25 years? It's a long time. I know their kids. Their kids have called me. I know their situation. I know their assets. I know everything. So talking about the changes we need were very easy because I already knew everything. Okay? And they feel comfortable because I know them. I know their family. I know their family situation. So it's a process. It changes as your family situation changes, as your assets change, as your health changes. Okay? These documents should not just be signed and put away. They need to be updated and revised. Okay? So I am now done. I am going to figure out how to stop this. I did. And I will take questions both verbally and both in chat. Someone said it was $134 in the chat function. I don't know what that means. So I'm not going to answer that question. Okay. Okay, Marcia, you have a question. Yeah, there's a way you can raise your hand. If you're good at Zoom, there's a way to do that. So you can do that or you can just speak. But Marcia, speak first.
Okay, thank you. Well, first of all, thank you for the presentation. It was very thorough and very interesting. And though I'm already a senior, I picked up a lot of things that I thought were really helpful, and I appreciate that. I have a question about special trust planning. If you are interested in doing a trust for your beneficiaries, or one or more, how do you pick a trustee? If you don't have someone that you can identify to be that trustee, how do you find a trustee? And what's the cost involved?
So I'll tell you the cost involved first, because I don't think it matters. Oh, that was the amount that Hope got from the 401k plan. Okay, thank you. All right. So it normally costs 1% or so of the assets annually. So if it was $500,000, that's $5,000 annually. Okay. If it was $1 million, that's $10,000. Sometimes, as assets are more, some institutions tier their fees. For special needs trusts, we need either a lawyer or an accountant who knows how to deal with it. There are a couple of institutions in Maryland that are private institutions that serve as trustee of special needs trusts, and that's all they do. And then there are some corporate trustees who specialize in working with special needs trusts. None of those are located in Maryland, but they work in Maryland. Okay. So it just depends. Most special needs trusts end up paying for a care manager. Okay, either always or sometimes, because the trustee is not going to be the care manager.
Right,
You know what I mean? I'm sure.
Right.
Yeah.
right.
So they normally, well, so special needs trust needs to give authority to pay for a care manager, which ours do. Okay. The other party in a special needs trust sometimes is called a trust protector or a trust advisor. So that is someone who can maybe do something, maybe change the terms of the trust. Maybe the laws change and you need to change the terms of the trust. Maybe to change the trustee. We just spent 2 years getting the trustee changed because the current trustee would not serve as a trustee of a special needs trust. But the trust wouldn't qualify as a special needs trust, and they needed a special needs trust. So it took us 2 years to get everything lined up to have a special needs trust and a new trustee appointed. And what we did in that trust is put a trust protector in. So if we had to do this again, it would take hours instead of years. Okay, so sometimes it's a 3-party situation, but it depends on the assets, the beneficiary, and who we choose. Did that help?
Yeah.
Yes, thank you.
Trudy,
and-
you have a question. She raised her
do.
hand. She gets
Yes,
first.
Trudy did. And after Trudy, I'm going to read somebody private message me a question. So
Okay.
Trudy, go ahead.
I have a question. I have an advance directive and I have a MOLST. And I wonder, I can't remember what I did about like a medical power of attorney. I can't remember, but like, if I already have that, if I wind up at the hospital tomorrow, doesn't the MOLST like tell the doctor what I want without like a medical power of attorney being there?
Okay, I'm going to answer the question a little obnoxiously.
Okay.
What chance do you think you're going to have the most if you were taken in a ambulance?
I actually have it on my refrigerator.
That's right. That's where you're supposed to have it, or on the back of your door. And if you were rushing out to a hospital, are you likely to have that document? No.
Well, I thought they were supposed to look for it when they come.
Oh, if they come to you, they will look for it. Right.
Yeah, okay.
Okay. But if you right. So the only way, but if they come to you and they see the MOLST and they're not going to restart your heart. That's what it means.
Okay.
Okay. It
Mhm.
means they're not going to restart your heart. I do not know if they take the MOLST with them to the hospital,
Mhm.
but I know that what the MOLST document is a order signed by a doctor that says if the EMTs come to your house, don't restart the heart.
Or restart it if I tell them to.
Well, yes, they would probably restart it if you told them to.
Yeah. I think I
Okay,
have
if you
something
were-
like, I think
if
I
you-
have some little provision in there to, but whatever. I just wondered,
Yeah.
like, do they
an
have to call a
advanced-
person?
An advanced medical directive or a medical power of attorney covers many, many more situations than a MOLST does.
Okay.
A MOLST is for an emergency action. It's not for your stay in the hospital.
Okay.
Now, once you're in the hospital, a doctor may put on a DNR order,
Mhm.
but there are also other decisions that aren't covered. Suppose you broke your arm. Suppose you didn't want to eat. Suppose you had an infection. I can keep going.
Mhm.
So you need both. Well, I take it back. When you are old enough, you need both. Okay?
Mhm.
I don't think a 60-year-old should have a MOLST form. That's my personal opinion. Okay? Because most 60-year-olds, if they had a heart attack, they would want to be resuscitated. But if you're 90 years old, you probably should have a MULST form. Because if you have a heart attack, you may not want to be resuscitated. So you have to want that at that time. And I don't think 60-year-olds, even 70-year-olds probably want to make that decision. Again, that's my personal decision, having talked to a lot of people about it. And when I tell them what it is, and they're 65 years old, they say, no, I don't want that. Okay. But when they're 85, they say, yeah, that's a good idea. But it's a doctor-ordered signed form. I can't do it.
But I guess still part of that was, if I have, say I have the most and I have the advanced medical directive, what would a medical power of attorney person do? Because it's already written down. Aren't they going to just say, well, this is what you...
Well, your medical directive probably has a medical power of attorney as part of its provisions. And again, I've had many clients end up in a hospital and their kids tell me, Dad wants to be kept alive. And the hospital has a MULST form or a living will that says, no, he shouldn't be. And there becomes a big fight. Most of my clients, most of the people I speak to, tend to want a person to make most decisions for them if they're in a hospital. That's a choice, and the choice is dependent upon you and your family and your people who you want to make decisions for. It's a very personal choice, too. So both documents could be very important, and a MULST is very narrow in its applicability. Stephanie, you had a question.
Okay, yes, thank you. Okay, so somebody had put in the chat, I've been informed that many people go through estate planning but do not fund them. What is involved in funding an estate plan, living trust? Does the client do this? Can the lawyer do this? What assets should be excluded from the estate plan?
Well, so
I know it's a lot of questions.
Well, it's really one question, and it's a great question. Okay. If someone does a revocable living trust and does not retitle their assets, then it's a waste of money. So if you have a revocable living trust, you need to have your assets titled in the revocable trust. And what I mean by that generally is your house or any other piece of real estate you own and any major financial asset you own. Most people do not title their checking account in their revocable trust. Some people do, but most do not. Some people change the beneficiary of life insurance policies and retirement accounts to be their revocable trust. Sometimes it should make sense, sometimes it does not. We tell our clients what to do. We contact our clients' financial advisors and tell them what to do, because I want my clients to know what to do, because if they change financial advisor or go from Schwab to Fidelity and I did it for them, they would not know what to do and they would make a mistake. So we train's the bad word. We teach our clients what we want them to do. We give them information in writing and email about how things should be done. And then we help them either by contacting their financial advisors, completing forms for them, or answering their questions. And there are some lawyers who will actually, and we will too, if you really want, we will take you and retitle the assets, but it means going with you to the banks and the financial institutions to do things, and that just becomes very costly. So most people would rather try it on their own, and a lot of my clients have financial advisors who will do it for them.
Okay,
I think that
thank
answered
you.
the question.
Yes. And then another one in the chat is, do all trustees get 1% of the assets annually or just corporate trustees?
Well, normally when someone is the trustee of an ongoing trust, whether it's for a special needs child, someone who's dysfunctional, or for whatever, or cancer, is spendthrift. Normally, if that person is a professional, they will get paid. If you name your brother or your nephew may not want to get paid. So it depends on who you choose. I believe anyone who's the trustee of an ongoing trust should get paid. It is a lot of work. More work than you can imagine. And it's also work that could get you embroiled in a lawsuit. Because if I'm the trustee for your son and your son decides I'm not being nice to him, I'm not giving him $1,000 more to go gambling at MGM. He may file a bad review for me, or he may hire a lawyer to fight me. I have had clients who are trustees for their siblings have to fight in a lawsuit against their own sibling who says they're not doing the right thing when they were. So I think all trustees should get paid something.
Okay.
My own personal opinion.
We have another question in the chat. How best to protect an estate when going into a nursing home, for example, or other situations when the estate must be spent down? Okay,
There's Medicaid planning is either what's called crisis Medicaid planning. You're going to go into a nursing home tomorrow or next week or next month, and thoughtful Medicaid planning, which is I may go in a nursing home 5 or 10 years from now. So first off, long-term care insurance is a great tool. Okay, everyone can get long-term care insurance. There are hybrid policies now, and I wouldn't get a straight long-term care. I would get what's called a hybrid policy. And a hybrid policy is like a CD or an investment, or sometimes a life insurance policy. And there are some very, very good people who do this work. I don't sell long-term care insurance. I know people who do, and I know that if you're concerned about entering a nursing home, that's the first thing you should consider. The second thing you should consider is whether or not you are willing to give up control over your own assets. Because if you want to protect your assets from being used, if you enter into a nursing home, you have to give up control over your own assets 5 years or more before you enter into a nursing home. So today, okay, if you have control over it, the nursing home may say, you still have to use it. So you have to give up control. You may be entitled to get the income, but then the income will be used if you go into a nursing home. Okay? So look at it this way. If you really want to protect your assets for your kids, you have to give them to your kid, the assets to your kids now, 5 years before you go into a nursing home. We use a trust to do it instead of giving it to your kids directly so that your kids won't spend it until you're dead. And they'll maybe use it for you if necessary. So that's planning. If you're going to go into a nursing home tomorrow or a week from now or a month from now, I'm not the right lawyer for you because I don't do this type of planning, but you would go out and prepay your funeral expenses. You would go out and do some other things. The lawyers who do this planning charge a lot of money because it's either pay the lawyer or use the money for a nursing home. So, I mean, the lawyers I refer to charge about $25,000 to do this planning. And that's the reason why. Because you're either going to go into a nursing home and spend your money, or they're gonna do some trick to save some of your money and not be spent for a nursing home. But they're gonna tell you to go prepay your funeral home. If you need a new car, go buy a new car. If you have a house, maybe pay off your mortgage. Okay? Because those things are not counted against you, as are payments to lawyers. Okay?
Thank you. Well, I just want to ask, we have time for one more question possibly, but I know it's getting late and I want to be respectful of everybody's time. Does anybody have a question? Oh, yes. Go ahead, Carolyn.
I just wanted to ask, you were talking about the metropolitan area. If a will is made in Virginia, the person moves to Maryland, is the will still valid?
It may be valid, but it may need to be updated and revised. Okay, there are different laws in Maryland and Virginia, especially around powers of attorney, that need to be taken into account. There are some other provisions and things that are also different. I know on the slides it had my contact information, but frankly, if you Google me, I come up very easily if you want to contact me, or just ask Stephanie, by the way.
Okay. And Gary, you're okay if I share the slides for anybody?
Absolutely, positively. I went through them today. There should be no spelling mistakes. So,
one last question. Do you serve people that live in Virginia?
yes, we work. Our primary area is DC, Maryland, and Virginia. We will work with clients also sometimes in Florida, New York, and some other states, but mostly it's Maryland, DC, and Virginia. We meet with people in person, and also like this in Zoom. Okay, we allow the client to decide. Okay, I'm old school. I like in person, but not everyone feels comfortable.
Well, Gary, thank you so much for being here with us tonight, for sharing all this information.
Can I ask something very quickly?
Yes.
Sure.
I just, the terminology, somebody talked about a MOST document. There's some acronym there that I didn't, the emergency.
MOLST, Maryland Orders for Life-Sustaining Treatment.
Thank you. I just
You
wanted
would
to
go
know
ask
what
your doctor about it.
Thank you. Just wanted to clarify the acronym. Thank you.
Thanks. Well, thank you everybody for being here, for asking such good questions. And Gary, thank you again for sharing all this information. And I think, what you shared, it's a process, and also there's really so much information. It's always changing, and that everybody should be thinking about and looking at, their documentation, and having, all this information at hand is super helpful. So thank you.
My pleasure.
Thank you.
I
All
hope
right.
everybody has a good night.
Thank you so
Thank
much.
you.
Thank you.
Thank you. Bye-bye.
Thank you.
Everybody.
Bye.
Bye.